Welcome back. We're going to continue to build on our appreciation of the law of property and the role that claims to private property rights play in the evolution of environmental law. Last week, introducing ourselves to the idea of regulatory takings under the Just Compensation Clause of the U.S. Constitution, we looked at those instances in which an environmental regulation, for example, might require payment to the extent it interferes too much with a private property owner's reasonable investment-backed expectations. That's what the court held in Penn Central versus New York. This week, we're going to leave urban downtown Manhattan for the beach. In this case, the coast in South Carolina in the southeastern United States, where in 1988, the South Carolina legislature adopted new rules governing the development of property on its beaches. The South Carolina legislature adopted a new setback requirement, shown here as a dotted line on the chart, and insisted that any new building of homes must take place on the landward side of that line, or to the left of the line, and not to the right or the seaward side, closer to the coast. The state had its reasons for doing this. For one thing, it had learned, because of rising sea levels and increased surge, that homes built too close to the ocean stood in constant danger of erosion. Moreover, in times of violent weather, like the hurricanes that occasionally hit the South Carolina coast, those homes could be destroyed and in turn become something like battering rams as pieces of them threatened other homes to take them out. The further away from the violence of the dynamic part of the coast, the better, was the bottom line for the South Carolina legislature, and it adopted this new setback requirement. David Lucas was a property owner that bought land prior to the adoption of the new setback requirement, and his land was on the ocean side, the seaward side of the line. Let me remind us that at the time he purchased, it was perfectly legal to build homes on that side of the line. Not only that, but he paid real money, about $500,000 per lot for 2 lots, on one of which he wanted to build his home, and on the other he was going to build to sell. But that's $1 million in investment. And yet, before he could build, the state adopted its new setback requirement, and under the new regulation, he was prohibited from building. He argued, this is a takings. I know the government didn't condemn my land through eminent domain, and I still hold the title, but the effect of this regulation is the same. It deprives me of my property. It's as if I don't own it. That is a regulatory takings, and I deserve to be paid. The Lucas opinion itself, this time, agreed with the landowner and held the Fifth Amendment requires compensation. What's especially interesting about Lucas, however, were some of the things the court said and some of the things it did not say. For example, rather than evaluating this under Penn Central and say on a case-by-case basis, this is an instance where the regulation just goes too far and requires compensation, the court instead stepped back and created a new category that will always require compensation. And the new category is this: whenever a regulation deprives a landowner of 100% of the economic value of his or her property, that's an automatic regulatory taking, and compensation has to be paid. We don't do any ad hoc balancing approach under Penn Central. And in this case, of course, the effect of the regulation seemed to be to deprive David Lucas of 100% of the economic value of his parcel. That said, there are some aspects of the Lucas opinion that are puzzling. For example, it is a little bit arbitrary to draw the line at 100% and not say that there's a categorical taking at, for example, 99% or 95%. Why 100%? What's so special about that? Because as the law now stands, if you don't fit in that very narrow category, even if it's a substantial interference, like a 70% or 80% diminution in market value, Lucas doesn't apply, and you have to evaluate whether it's a taking under Penn Central. But there's a second concern about Lucas, which is, even in those relatively few instances when the regulation, like here, deprived a landowner of 100% of his or her investment-backed expectations, the court made clear that even then, compensation wouldn't have to be paid if the state's rule was designed to prevent a nuisance. Because after all, no one has a right to maintain a nuisance at common law, and you shouldn't be paid for something to which you don't have a right. But here's the rub. Who's to say that the state's requirement didn't, in fact, reflect the state's new understanding of what a nuisance is? One of the dissenting judges in this case made just that point. He pointed out that the law of nuisance is changing, and under a new understanding of the dangers of building too close to the ocean right at the coast, what used to be thought of as innocuous, building a beach house, we now recognize as a nuisance, as dangerous. Who's to say that the state of South Carolina's common law of nuisance can't evolve? We've seen other instances in which the law of nuisance has a tradition of evolving over time. The Lucas majority never really addressed itself to that argument, except to say that it couldn't see how simply building a house could be a nuisance under any state's common law. But of course that doesn't really address the question, how about building a house here, on this particular property, right in this very dynamic environment at the coast? Justice Kennedy, concurring in the opinion in Lucas, made another point. He said, even if this isn't a nuisance at common law, people buy and sell property subject to understandings, background understandings of a state's property law. What about the judgment of the state legislature when it adopted the law in 1988 that there are new dangers from the coast that we as a legislature now want to pass a law about and make part of our police power of the state to protect the public good? How is the law to account for that? In fact, the judgment of the state legislature in 1988 to adopt the setback requirement was all too prescient. The very next year, a very powerful storm, Hurricane Hugo, not only slammed into the South Carolina coast, it hit almost exactly the point of contention at issue in this case. At the time, it was the most destructive hurricane ever to hit the United States, and it made Justice Kennedy's opinion look all the more prescient, all the more persuasive. What about legislative judgments about the new rules of the road for property for the public good? The majority never really addressed what to do about these types of new understandings that are part of the background understandings of property law. There's another concern about the Lucas opinion. It's sometimes called the denominator problem. Lucas didn't disagree with the result in Penn Central that we're supposed to look at the property as a whole. And at first blush, it seems that this case is sort of an easy call. There seemed to be two lots that David Lucas owned. Both of them he was prohibited from building on, and that looks like 2 out of 2 lots, or 100% of his property, he was deprived the economic value of. But it might not really be that simple. David Lucas, in fact, was a land developer who had built other homes very close to this area on the Isle of Palms off the South Carolina coast in his lifetime. What if he built, let's say, 300 homes, and these two were the 301st and 302nd parcel? Well, the new setback requirement, if we take this wider angle lens, really deprived him of rights only to 2 of the 302 properties he developed over his lifetime. That's nothing really like a 100% wipeout, and the issue is, isn't it a bit arbitrary to simply put a frame around this problem and only look at the 2 parcels without looking from a broader point of view of, in fact, his connection to the South Carolina coast over time? The court really never argued why its denominator, 2 properties only, was not an arbitrary classification. But perhaps one of the central concerns about the Lucas opinion is that it puts so much emphasis on looking at the role of land solely in what has been called the transformative economy. Joseph Sachs, a wonderful law professor now at University of California, Berkeley School of Law, used this phrase in a very powerful essay in which he acknowledged that land certainly is often seen as an input in the transformative economy to be mixed with other inputs to produce private goods. And looked at that way, these lots were certainly part of the transformative economy. After all, they were valuable parcels in the transformative economy, valued at $500,000 each. And yet, can't we also see that same land as playing a role in what we might call the economy of nature. We now know that sand provides very useful ecosystem services for everybody. We now know, given the new understanding of geology at the beach, that this sand is necessary to move and be resilient in the face of a very dynamic sea, in the face of very dynamic weather, to rebuild and bend exactly these sorts of beaches and coastal barrier islands to preserve them for the future. When we interfere with them, we interfere with some of the very strong benefits we get from resilient beaches like this, such as the development of new sand dunes that would protect inland properties from even more devastation from storms in the future. In the late 1990s, some natural resource economists tried to step back and put a dollar value on all the ecosystem services that might be provided to humans in the world. They came up with a figure, an estimate, $33 trillion. The relevant thing about that number is at the time it was made, in the late 1990s, the gross domestic product of the entire world economies of the transformative economy was only $18 trillion. We'll put two and two together. What that means is there isn't enough money in the world that we generate in the transformative economy to pay for the services nature provides us. If the Fifth Amendment requires us to pay too much, there's not enough money in the world by which we can buy back our planet for the valuable contributions it makes even to our own survival. All of those things are bound up in the lasting influence of Lucas. Since Lucas was decided, there have been a couple of developments that shed light on this ongoing tension. Perhaps the most significant of those was a court case that also took place at the coast a few years after Lucas was decided. It took place up north in the northern coast in the United States, in the state of Rhode Island, where a landowner named Anthony Palazzolo bought some land right at the coast consisting of part of the parcel being uplands on which he could build homes, and part of the parcel being submerged wetlands, part of a tidal pond that played a very important role in the coastal ecosystem in this part of the world. He had hoped, when he purchased the property, to be able to fill in the submerged parts and build even more homes for sale. But when he went to apply for the permits, the state denied him those rights. After going up and down to the Supreme Court once, it went back to the Rhode Island courts to finally determine whether or not that constituted a takings of his parcel. It certainly wasn't a categorical takings because failure to give him a permit to fill in the submerged land didn't deprive him at all of the ability to deal with his uplands, so it wasn't a categorical taking under Lucas. Under Penn Central, however, even then, the Rhode Island courts held no payment was required, and the reasons were twofold. Number one, the court held in Rhode Island, we now appreciate that filling in wetlands, tidal pools like this, constitutes a nuisance under Rhode Island state common law. Pointing out that the ecosystem services provided by the pond that we now appreciate would be lost if that would be to fill in, the court said this is really no different than other nuisances. Accordingly, since no one has a right to maintain a nuisance, you haven't been deprived of something to which you had a right. Even if it's not a nuisance, the court said, secondly, the state holds submerged lands like this subject to the public trust doctrine, and so too did you, Mr. Palazzolo. When you purchased title to this part of the land underneath the water, you took it subject to the state's superior interest in managing that for the public trust. And the public trust now realizes that the ecosystem services provided to the coast by this very important dynamic coastal pond are so great that filling it in would violate the public trust. And accordingly, since you really never had the right to have land to be held in derogation of the public trust to begin with, we haven't deprived you of something to which you have a right. No compensation needs to be paid. Both aspects of the Palazzolo opinion reflect just the sort of appreciation of the economy of nature that Joseph Sachs talked about, and they demarcate one of the front lines in the battle between property rights and environmental protection. Next time, we're going to step back and look at a very important theoretical aspect of property that we haven't yet talked. I'll dress up in a tuxedo, so don't forget to tune in. I'll see you then.